We live? Okay. Good morning, everyone. It is Tuesday, March 16th, 2021. These are the detention hearings for the 323rd Judicial Court of the State of Texas, Tarrant County's designated juvenile court. The Texas Supreme Court, in its various emergency orders, has directed courthouses of the state of Texas to generally close their doors except for essential hearings. However, in keeping with the spirit of the open courts provision of the Texas Constitution, these hearings are being broadcast live on YouTube, except where counseled against by Section 5408 of the Texas Family Code. Recording or rebroadcasting all or part of these hearings is expressly forbidden. Violation of the court's order may subject you to civil and/or criminal contempt proceedings. First on our docket this morning is Angel Alejo Aruvo. All right, are you Mr. Arujo?
Yes, sir.
Am I pronouncing your last name correctly?
Aruvo.
Araujo, okay. Mr. Araujo, the law says when you're brought into detention, you must see a judge within 2 business days. This is your initial detention hearing. You have the right to remain silent. You also have the right to an attorney, and I've appointed Frank Adler to be your attorney today. According to information provided to us from the police department, you were referred in custody by the Arlington Police Department for the offense of burglary of vehicles back in February 5th of 2021. According to the police report, at approximately 2:48 in the morning, officers were dispatched to a burglary in progress at a residence. According to the report, a female suspect was breaking into the complainant's vehicle. Upon arrival, a male and female suspect were detained. The officer interviewed you, and you admitted to breaking into a vehicle. More recently, you were referred out of custody by the Arlington Police Department for the offense of aggravated robbery. According to that police report, on January 13th, 2021, at approximately 10:44 at night, an officer was dispatched to an apartment complex in the Arlington area regarding a shooting in progress. The call text stated that 2 males had just shot at a complainant's vehicle while he was in the vehicle and his 2 daughters. The suspect then left the scene on foot. Upon arrival, officers observed both windows to the passenger side of the victim's vehicle had been shattered. Officers later contacted the complainant, spoke with one of the witnesses, and she reported that she was friends with you. She reported that the clothes you were wearing on the night of the offense was the same as the clothes you'd worn to her house several days earlier. She recognized the backpack that you were wearing and recognized your voice during the commission of the offense. On February 8th, a detective met with you at your residence, and you reported that on the evening of the offense, you were under the influence of Xanax for the first time and not in your right mind. But you confirmed that you had a BB gun rifle and pointed the gun at the father of the victim. Subsequently, a progress report was submitted to the court on February 26th, and Judge Kim thereafter issued a DTA regarding the new offense for aggravated robbery, and that is the reason you were brought into today. Mr. Adler, what are your thoughts?
Judge Porter, I don't see is the parent on?
Your Honor, she indicated that she could not participate in person, and she was provided the Zoom link, and I don't think she's logged in yet.
Well, just based on that, Judge, we've got nothing today. I'll have a conversation with the mom for the next detention hearing.
All right. I'll mark that. No present or guardian was present, so Mr. Adler, you are appointed today for the purposes of this hearing as both the attorney and guardian ad litem. First, I will find that probable cause exists and continues to exist to believe that you engaged in delinquent conduct sufficient to warrant your initial detention for the offense of aggravated robbery. I will further find that there's no suitable supervision to be release you to at this time, and I will order your continued detention. And that will be the order of the court. Thank you, sir.
Wait, Judge Porter.
Are you going to tell me something, or do you want to ask a question?
I want to ask you a question.
What is your question, sir?
When do I got my next detention hearing? And
It'll be in 10 business days or probably about 2 weeks.
okay, so I got to be in level 1.
You got to be level 1 to be considered for release, but that decision will most likely be made by Judge Kim or Judge Terry at the time. Because you're charged with a gun-related offense, I will warn you that it's not a guarantee you're getting out next time, even if you maintain level 1-0 between now and then. Judge Kim takes gun crimes, even if it's a BB gun, very seriously. And so he's a little bit more cautious in gun-related crimes. So the best thing you can do to help Mr. Adler out, to argue on your behalf next time, is to get to level 1-0 and maintain it continuously. If you don't do that, I can guarantee you won't be considered for release. All right?
Yes, sir.
That'll be the order of the court. Thank you, sir.
Thank you, Judge.
Nash, Bryson Burns. Good morning, Mr. Lofton.
Good morning, Judge. How's everybody doing?
Better than we deserve. How are you?
You're great, sir. Thank you.
All right. Are you Mr. Burns?
Yes, Your Honor.
Mr. Burns, my name is Judge Porter. The law says when you're brought into detention, you must see a judge within 2 business days. So this is your initial detention hearing. You have the right to remain silent. You also have the right to an attorney. And I've appointed Trent Lofton to be your attorney. Mr. Dotson, do we have a parent or guardian here today?
Yes, Miss Bernadette Burns. I see her name, but I don't see her face.
Okay.
And may I explain to you this situation before you get started?
Yes, sir. What brings Mr. Burns to court today?
Initially on March 9th, he was detained for out of custody hearing by Judge Terry. She ordered that he be released to go to his doc's appointment on yesterday. So he was released yesterday at 12:50, came back at 16:50 from his doctor's appointment. And that's why he is getting a new detention hearing, but actually he's been here since the 9th and he's been on level 1, I guess, since the 15th of this month. So now he does have case pending, and his court is set for the 5th of April for aggravated assault, family member, and possession of a controlled substance. And he does have a history of violating his monitor, and he was listed as a runaway, which was why he was detained on the 9th. And he tested positive on 9th for marijuana, but yesterday he tested clean.
All right.
Judge, I apologize. I don't mean to interrupt. I don't think it's aggravated assault of a family. I think it's just assault bodily injury of a family, I believe. And
No, if I say aggravated, you're right.
okay, again, I probably said that too. So I apologize, sir. But excuse me, Judge. I'll shut up.
Mr. Lofton, do you want to ask Ms. Burns some questions?
Yes, sir. Miss Burns, what do you feel about him being released? And did you tell the judge of his health problems, please?
I'm absolutely okay with it. I'm more worried about his health in there. I love my son. Yes, I want him home.
What's the condition with his health, ma'am? Can you tell Judge? I don't think Judge Porter knows.
He's a type 1 diabetic.
Okay. Does it require constant insulin shots and care and round the clock? Okay. And Judge, any questions the DA or y'all have, we would pass the witness on that.
Mr. Dotson, what other referrals has Mr. Burns had to the department?
He's this is his first time with we got the controlled substance charge referral on November the 14th, and then December he has the family assault of bodily injury. So those are only 2 referrals other than local runaway and director's apprehend. But the possession of the controlled substance in November and the assault in December are only 2 charges, 2 referrals he has with cases.
Was that the possession of controlled substance, is that a vape cartridge?
It was a vape cartridge with yellow liquid that they determined to be marijuana oil,
Okay.
THC oil.
Okay.
Mr. Burns, I'm sorry, Mr. Dotson, how long has he maintained level 1 outstanding?
Your Honor, he just got to level 1 yesterday. I believe, let me make sure, that's in the time fashion since he got here on the 9th. I don't see any other, let me make sure.
I think he always stayed level 1.
Yes. He made level 1 yesterday. And it took 6 days. That's what it's supposed to take when you come in. So.
Give me just a minute.
Right.
Okay, well, I released him on the monitor back on January 4th, and less than 10 days later, he's already jumping the monitor at 11 o'clock at night. Mom, what are you going to do to make sure that he's not jumping the monitor again?
I think he's learned his lesson.
That's really equivocal. I think
Honestly,
is not a definite he's learned his lesson. I
I
hope, I
absolutely-
believe, I aspire. No. Have you put any alarms on the door, on his bedroom door?
I'm going to have to.
So you haven't done it yet?
No.
Okay. Tell me why not.
Because our living situation.
Hold on just a minute. Have you enrolled him in school yet?
Yes, he goes to Richland Middle.
Okay.
And he was starting to do good again. I think if we keep him on the focus of going to school, he's going to do much better.
Mr. Dotson, the release to go to the doctor's appointment yesterday, what was that time out for? I mean, what was that window of time?
He was released at 12:50 p.m. and he was officially brought back in at 16:51. So it's like 4-hour time.
What was the time frame allowed for? What was the deadline to bring him back yesterday?
She never set a deadline. She just said come back directly after the doctor's appointment. So.
And we did that.
Looking at the 4-hour window, and she had to use an Uber. I determined 4 hours might be appropriate for a diabetic exam, and waiting on the Uber and coming back.
Okay. All right. I'm going to take another chance on you, Mr. Burns. I'll authorize your release on the electronic monitor. I'm also going to order that you be hooked up with a sweat patch. If you tamper with that sweat patch, if you tamper with that monitor, I'll consider those violations and you're likely to come back to detention, where you will have to stay or get to level 1.0 next time and maintain it for 10 business days before we will consider your release. Okay?
Yes,
So
Your Honor.
next time, this is not an easy thing. Next time you're going to come back. If you violate, you're going to come back and stay for an extended period. And we'll just keep doing this all the way up to your 18th birthday if we have to. You understand that?
Yes, Your Honor.
All right. That'll be the order of the court.
Thank you.
Thank you, Your Honor.
Thank you, sir.
Thank you, Mr. Dotson. Thank you, Mr. Lofted. All right. Tayesha
Yes,
Lozano. Are you Ms. Lozano?
yes, Judge.
How are you today?
I'm doing fine. How are you?
Better than I deserve. Ms. Lozano, My name is Judge Porter. The law says when you're brought into detention and initially detained, you must see a judge every 10 business days. This is your 10-day hearing. You have the right to remain silent. You also have the right to an attorney, and your attorney, Rafael Sierra, is here. The court has previously found that probable cause exists to believe that you engaged in delinquent conduct sufficient to warrant your initial detention. I will note that you've been level 1-0 since March 8th of this year. So nearly, 8 calendar days. Mr. Sierra, what are your thoughts?
Your Honor, I've spoken to her mother. She has no prior incidences or criminal history. I asked her if there was any ongoing problems at home. She replied by saying this was a single incident and that she had never done this before. She does not have any mental health issues or history at this time, and there's no reason to believe. Mom also said that she's willing to pick her up, take her home, and she's willing to bring her to a future court date, Your Honor, if you were to release her.
Mr. Sierra, this is not Ms. Lozano's only referral to the department, is it? In fact, she's had 2 or 3 referrals, 2 of which were previously dismissed because Mom and Ms. Lozano failed to ever show up to JPD to complete intake. Isn't that correct?
Your Honor, I'm in place of Felicia Guerrero.
Yes, sir.
And according to what was stated in the detention hearing report, Ms. Guerrero was the one who stated that there was some challenges and difficulties bringing the mom and the young person for intakes.
And Mr. Ortiz, we both know Ms. Guerrero. She doesn't just make one attempt and then give up, does she?
That's correct, Your Honor.
She probably had multiple contacts. I would bet 4 or 5, don't you think?
Yes, Your Honor.
And then they just got ignored?
Yes, Your Honor.
Mr. Sierra, perhaps Mom, I need to hear from Mom's own mouth that she's willing to make sure Ms. Lozano comes back, because not real convinced.
Well, Judge, if you allow me, I'm willing to question her, but I'd have to translate.
That's
Did
okay.
you want me to go ahead and do that myself, or did you want me to translate for you, Your Honor?
It's up to you.
Buenos días.
Buenos días.
El juez quiere que le pregunte, el problema que existe es que ella tuvo corte antes y no la trajeron. Y él nomás quiere la asegurancia si usted se va a hacer responsable de traerla a corte la siguiente vez si la deja salir de detención.
Sí, sí.
¿Sí está dispuesta?
Sí, estoy dispuesta.
Your Honor, I asked what you asked me to do. She says she is willing to bring her.
Vamos a okay? Mama?
What was your question, Judge?
Did she promise to bring
Oh.
her back?
Señora, el juez le está preguntando, ¿usted prometa traer su hija para atrás al corte?
Sí.
Yes, Your Honor.
And when the probation officer needs to talk to Ms. Lozano or see Ms. Lozano, do you also promise to make Ms. Lozano available to the probation officer?
Usted también tiene que estar disponible al momento que cuando probación le hable a su hija o la quiere ver, que usted tiene que ser su parte y hacerla disponible para cumplir con los pedidos del oficial de probación.
Okay.
¿Está dispuesta a hacer eso?
Sí.
Yes, Your Honor.
Now, Mr. Sierra, I have a question that I'd like to ask Ms. Lozano,
Yes,
and I want to run it through you first. Does Ms. Lozano promise not to intercept messages from the probation officer that are meant for her mother, either phone calls or letters?
Judge, I think you're making a reasonable request.
And if we have reason to believe, as we like to say in family law, that interception is occurring, does Ms. Lozano also understand that I will issue a directive to apprehend for Ms. Lozano and she'll just be back in detention?
Yes, Your Honor. I'd understand that. I'm sure she does as well.
I can see Ms. Lozano smiling underneath her mask. So that would constitute post-arrest silence. Okay.
Do you want her to respond to you, Judge?
No, that's okay. She's
Oh, you want
indicated.
me? Wait.
You've already answered my question, whether you realize it or not. Mr. Sierra, where's Ms. Lozano in school?
I would have to look at her file, Your Honor. I don't
Or
have.
maybe Mama knows.
Mamá, ¿cómo está su hija en la escuela?
Está bien.
¿En qué grado está?
Está en 9.
¿Y
Okay.
sus grados?
Sus grados son bien.
She's in school. She's in 9th grade, and her grades are good, Your Honor.
¿En el nombre de escuela?
South Hills.
Okay, ¿cómo?
South Hills.
I couldn't understand her through her mask.
South Hills.
Oh, okay. Thank you, Ms. Lozano. Okay. Mr. Ortiz, given our problems with
Yes, Your Honor.
ensuring her coming to court when she's supposed to, is this an appropriate case for an electronic monitor? Mr. Ortiz?
If the history is from what you stated, Your Honor, I wouldn't deny that. But
Are you sure you're not a lawyer, Mr. Ortiz? That's a real waffle answer.
I'm very far from that, Your Honor.
Mr. Ortiz, any indication in her history that there's, oh, yes, there is. When she came in on the 1st, she was positive for marijuana. Okay. Okay. I'm going to authorize her release, Mr. Sierra, on the electronic monitor and with a sweat patch. Ms. Lozano, if you tamper with either the monitor or the sweat patch, I'll consider that a failure. I will most likely issue a directive to apprehend. You will be back in detention, where next time you will get to stay at Uncle Medlin's bed and breakfast for a period of at least 10 days once you maintain level 1.0 before I'll consider your release. So next time, it's going to be even harder. If you test positive for marijuana, if you tamper with your monitor, what's going to happen?
I'm gonna get detained.
And you got to stay longer next time. And we'll keep doing this all the way up to until you're 18 if we have to.
Thank you so much.
All right. That'll be the order of the court.
Thank you, Your Honor.
Thank you, Judge.
Boy, I'm a big softy today. All right. Oh, well. Oh, well.
Everyone's grateful, Your Honor.
It's only because it's the day before St. Patrick's Day. All right. Please don't bring in the next child yet. Detention. Yeah, if you'll turn that. Okay. Pursuant to Section 5408, subsection C of the Texas Family Code, the court finds that the remaining cases involve children under the age of 14. And under that section of the Family Code, there is a presumption that the child's right to privacy outweighs the public's interest in participating and viewing those detention hearings. No contrary evidence has been brought forth to the court, and so the court makes the affirmative finding that the child's privacy interest outweighs the public's right to participate in the remaining hearings. I will stop the YouTube live stream And we'll give it about 30 seconds of burn off time. Stop the lecture.